Alright, hello and welcome to this evidence video capsule. Today I'm going to be touching on an evidence topic that's come up a lot in a bunch of recent cases. I want to touch on some of the tricky issues that can arise when somebody is trying to argue that an opposing party has waived legal advice privilege. And the reason they've waived it is because they've put their state of mind in issue. So let's dig into this problem, and I'll talk about a couple of recent cases that I think have really done some good work to strengthen the privilege, recognize how difficult it is to waive by putting your state of mind in issue. So let me start off by giving you a classic case where this needs to be resolved. And I mean, obviously, let's start from the proposition that privilege or legal advice privilege has been many times stated that this privilege is a very strong privilege. And it's very hard to put the privilege aside. So in all the examples that I'm going to give you, let's assume the privilege is valid. It's a valid communication between lawyer and client, so no issues there. Waiver can occur in a number of ways. One of them is where you expressly waive. I'm not interested in that. But you can also waive where it's necessary, and what I call the key criteria is where fairness requires it. And that's really the touchstone of waiver. The idea that a party, by their actions, has done something to waive privilege. How does that arise in state of mind? Well, here's a classic example. So let's say you have a civil action where A and B are in a dispute, and the issue is, I don't know, let's say it's a wrongful dismissal. So A is suing B for a wrongful dismissal. B talks about what happened during the claim. And B says, is examined on discovery, you know, well, why did you choose to take a particular course of action that led to the firing of my client A? And B says, I consulted with counsel, we decided that these steps were necessary, and we acted accordingly. Okay, great. Well, what did you talk about with counsel? We can't tell you. Privilege. All right. The idea of whether these communications are privileged is a really important one to explore. And let's, again, assuming there is a valid privilege, it's client-lawyer, you're getting legal advice. The basic idea is that when B makes this an issue by saying that they spoke with counsel and acted on counsel's instructions, that usually tends to waive the privilege. And the reason is that they are now essentially pleading that they acted in good faith because they consulted with counsel. Great. Well, that good faith claim is going to be relevant to the resolution of the wrongful dismissal claim. And that good faith claim is also going to require A, as a matter of fairness, to be able to know what was said. In other words, the essence of B's claim rests on this idea of this privileged communication. In that circumstance, that is called B put their state of mind in issue. And what that means is, this is a bit messy, so let me clear this up. B has effectively put their state of mind in issue by saying that we are relying on this communication with the lawyer. And it's only fair for A to be able to access, in other words, pierce the veil, because B has relied on this communication. May sound straightforward. It's generally based on the idea of fairness. It's unfair for a party to be able, I'll actually read for you, it would be unfair for a party to set up a claim or defense based on a privileged communication to preclude their opponent from discovering against that claim by relying on privilege. That would make no sense. So privilege allows you to discuss things with your lawyers and obtain legal advice, but if you want to rely on that legal advice as set up a pillar of your defense, good faith in the circumstances I gave you, that would be unfair, and therefore the privilege will be set aside. Sounds simple? Anything but. Civil claims are very complex, and a lot of different things can arise to raise situations that look like state of mind an issue. And I'm going to give you the common thread. What I think the golden thread to all this is fairness. If you think of state of mind privilege as an idea of you need this information, you're going down the wrong path. You always need solicitor-client privilege information. It's usually the best evidence there is. Need is one criteria, but it is not the primary criteria for deciding when a state of mind waiver has been established. And I'll show you what I mean by that by the following example that I think is a really good one from a very recent case. So the case that I commend to you is Leget and Jennings. It's a case from the Ontario Superior Court, and it sort of delves into these issues in more detail. Facts are pretty straightforward. Leget and Jennings were involved in a pretty complex financial dispute, and they got into a settlement. So they essentially settled, and they were going to resolve everything, except that the settlement ran into stumbling blocks. And essentially litigation now began, whereby one of the parties Leget wanted to enforce the settlement document, and Jennings said, no, the document is not good because you, Leget, made misrepresentations. Okay? So we're no longer going on the original dispute, which is irrelevant for our purposes. The only question is, should the settlement document be enforced? So discovery proceeded on all this. And essentially what happened in discovery, very simple. They asked about why you decided or why you believed there were misrepresentations. And through this process, essentially what happened is Jennings said, well, we had discussions, many discussions with our solicitors at this time that led to us resiling from the settlement agreement. But they said over and over again that the key was we believe there were representations, misrepresentations by your clients. And when they went to their lawyers, they brought these misrepresentations and discussed what impact that would have on the settlement document, right? And that eventually led to the litigation. So here's what happened. As soon as they discovered this, in the discovery, Leget said, well, we want all the privileged documents. Why? Because the relevant time at which the settlement, you decided to step away from the settlement, your state of mind is critical. So think about that. There's no doubt that it's true. Their state of mind at that relevant time was very, very important. And, they were deciding whether or not to step away from the settlement. They met with their lawyers. They discussed it. There's no question that that's important. They said they relied on misrepresentations, but maybe that's not true. Maybe the privileged documents would reveal that this was, in fact, some other reason for stepping away. So Leget said that fairness requires you have waived when you said you relied on discussions with your lawyers. That waives the privilege. And what did the court say? Not a chance. And here's why. The court made a very important distinction, and I think it's a really useful distinction between these types of things. As I said earlier, need is one criteria, but the second is reliance. Essentially, think of it this way. Solicitor-client privilege, legal advice privilege, whatever you want to call it, is the most important privilege that there is. It is not going to be lightly set aside. And as I tell my students in class over and over again, essentially, the client must use the privilege in some way to advance their claim as what I call a sword. They have to use the privilege. So you go back to the wrongful dismissal example, those guys used the privilege. They tried to plead bad faith as a defense. They used it actively as a sword. And in that case, fairness dictates if you're going to use privilege as a sword, you're going to lose the privilege. That's the way it is. But these guys, even though their state of mind was relevant, there was the need, a lot of relevance there, they weren't actively relying on the legal advice. In other words, think of it again, the legal advice would shed a lot of light on what they were doing, but that's not enough. The only time you take away privilege is where a party uses it as a sword. And Jennings wasn't doing that. They said over and over again, we resolved from the settlement document because of misrepresentations. The fact that the lawyer's communications might show that not to be true, and I'm not saying it was, I'm just saying it might shed light on that, irrelevant. That's need. They never said we relied on legal advice to break the contract, and for that reason alone, the claim was dismissed. The privilege was allowed to hold up. Whether or not privilege would help shed light is not good enough. I mean, imagine somebody confessed to their lawyer and said, I'm guilty of the crime. That would shed light on the murder trial. Not enough. Unless you aggressively use this as a sword, that privilege will be entitled to stand. And here's the holding in the case. So the presence or absence of legal advice must be relevant. In other words, it must be material to the lawsuit. And no question in Leget and Jennings, they satisfied branch 1. But there's an and there. And this is what I think too often courts forget. And there are a lot of cases that don't, adhere to Leget versus Jennings and the principles set out therein as closely. But this is the key. If you don't make the receipt of legal advice an issue in the claim, you can't be disentitled from relying on the privilege. They never did it. they didn't lose privilege in that case. And those two criteria are what make state of mind waiver so difficult to obtain. And that's enough to deal with Leget and Jennings. I want to just bring out one other point, because here's what's interesting. It's very rare, but it's possible to actually satisfy number 2, but not satisfy number 1. And the privilege doesn't fall if you don't need the material. In other words, the fact the material might be, fun to look through and useful is not a good enough reason to have it. It has to be material to the lawsuit, or to put it as some courts have, it has to be necessary in that it'll really shed light on what is going on. Otherwise, we don't pierce the privilege. And a great case to show how that works is Doman Forest Products Limited versus Gmat Commercial Credit Corporation. Really useful case to sort of show a different version of what can happen in these particular cases. And this case involved a very, very simple, or relatively simple, breach of contract. And one of the defenses that the defendant was raising was that the plaintiffs had waived their right to act on repudiation. Okay, so they took several months to terminate the contract. It's a complex commercial arrangement. Don't worry too much about the details. But during examination for discovery, the plaintiff suggested that they obtained legal advice when the decision was made not to act on the alleged breach of contract immediately. Okay, so essentially, let's assume for the moment, and the court did, that reliance had been had. Let's assume that the plaintiff acted with a shield. Okay? That was it. They acted with a sword. They came out and said, we spoke to our lawyers and we acted in a particular way. Great. Here's the thing about Doman Forest Products Limited. The court looked over everything and said, it doesn't matter that they spoke with their lawyers. It had no bearing on the legal issues in the case. The simple issue for the court to consider was whether or not there was appropriate bearing or appropriate legal basis to waive their right to continue to pursue the breach of contract. And that was a legal matter. It didn't matter the way they had acted. It wasn't relevant that they had sought legal advice. So in this unusual case, they had actually relied in their pleadings or in discovery on the fact that they had obtained legal advice. But since that legal advice would have been interesting but not material to the legal issues in dispute, they did not satisfy one of the two conditions for state of mind waiver. State of mind waiver issues arise a lot. They're raised all the time in civil cases as a way to try to pierce through privileged material, because it's always great to be able to, inspect correspondence between lawyers and clients. But the courts have been really good lately at upholding it. You will find cases to the contrary, but I think Leget versus Jennings and this Doman case are good examples of how difficult it is, really, unless you have reliance and need, the two keys to state of mind waiver. Hope that was interesting to you. Good little vlog on some evidence issues that come up a lot. And let me know. Have a nice day.